What's the date? 31st of October.
Good morning.
Hello, is this Mr. Coleman?
No, my name is Scott. I'm not Mr. Anything. My name is Scott William. I'm the living flesh and blood. Who may I ask, am I speaking to, please?
This is the President's Associate. Do you have the review this morning?
Do I have a review this morning?
Yes. Are you aware of the review that's occurring this morning?
I'm aware of fraud, yes. I'm also aware that I have questions to be answered before this matter can go forward, and some of those questions is, why has the Court of Appeal, which is a statutory body, only not answered my questions and shown me that they're under constitutional law? Now, before we go any further though, I'd like to ask, is it Debra Mullins? She is the President who requested this meeting this morning, is that correct?
So we're just about to commence court, if you're willing to wait just a minute.
Rightio.
Just 1 second. Silence, all right.
Appellant, are you on the phone?
Scott is on the phone, not appellant and not Mr. Coleman. No, I'm the flesh and blood and I have the equitable higher ground here. So make no mistake, I'm acting here as grantor. You are acting here in your fiduciary duty as trustee today. And for the record, I would like you to know, not that I'm required to tell you, that I have witnesses here today and I'm recording this conversation, so be honest.
Well, these proceedings are recorded.
Yes, I'm recording too. I'm fine with that.
Well, how are you recording it? Because
that's my business.
No, it is my business. This is my court.
Is it?
And I preside here, appellant, which is your designation.
Excuse me, objection, Your Honour. Objection. Objection, Deborah. My name is Scott, and you will refer to me as Scott.
I beg your pardon.
You can beg all you wish. You can beg all you wish, trustee. You're an administrator with statutory. You are an administrator with statutory jurisdiction, ma'am. Now, please remember your place. You have a fiduciary duty of care. I expect you to fulfill your fiduciary duty of care, ma'am. Now, please, if you stop raising your voice, I will stop raising mine. Let's calm down. Let's calm down, please. My name is Scott. My name is Scott, Deborah. My name is Scott, Deborah.
If you refer to me by my given name, I will interrupt you. This is a court of law.
Okay, well,
Justice Mullins who presides.
Rightio.
You may call me ma'am.
Let me ask you a question.
I'm happy for you to call me ma'am.
I am not.
President, Your Honour, Judge.
Okay,
Now,
so
you
need to. No, you need to understand that my name is Scott, not appellant.
My name is Anian Cooper, A-N-A-N-I-A-N Cooper, initials DJ. I'm instructed by Gaydon's lawyers, and I appear for the respondent, the Commonwealth Bank of Australia.
Thank you. Now, appellant, do you want the register?
Deborah, objection, Deborah, objection, Deborah, objection, Deborah. You've been objected to. If you cannot call me by my name, you need to stand down. You need to stand down. Your fiduciary duty is to me as trustee. You are a statutory body only. You have no jurisdiction unless I give it to you. And I want to put on and for the record in front of witnesses that you do not have my consent to contract or joiner, and anything you say or do will be used as evidence against you in a court of law. You have absolutely no authority whatsoever. Can you please stop insulting me?
Appellant,
Please stop assaulting me. Objection for your insults. Listen here, idiot. Stop insulting me.
Appellant,
I cannot hear your question because you are not referring to Scott. My name is Scott William. You need to address me by appropriate. And if you can achieve that, I will address you any way you choose as well, because I will show you the same respect you show me. You will call me Scott, and I will address you in any way you choose. If you continue to call me Pellant, Deborah, I will refer to you as administrator and as trustee. Are we actually going to do this, Deborah? Deborah, in your private capacity, as an administrator, as trustee, you will be held accountable in a court of law.
Do you want the registry to prepare the appeal record book at no cost to you? Do you want the registry to prepare the appeal record book at no cost to you?
This is going to cost Gaydon's and your private capacity as well as you acting outside jurisdiction, ma'am. So, until you can address me correctly, this conversation will not go forward. I have the equitable right to...
I'm not using anything to address you.
No.
I am asking
Objection.
you a question.
Objection.
I am asking you a question. All right.
Well, before we go any further, may I ask you a question? Are you in accordance with Chapter 3 of the 1901 Constitution? Are you in accordance? And is this in a tort of common law? I've asked these questions. I have asked you 13 times. I've emailed the Court of Appeal, Cooper, Barbara, all of the criminals acting outside jurisdiction using pen to steal property from others.
It is a matter of public record that all judges of the Supreme Court of Queensland are Chapter 3 judges under the Constitution of the Commonwealth of Australia, 1901, UK.
So we'll be following the Crown Proceedings Act today, will we?
And I have read the affidavit that you filed on that you filed for today's review. I just want to help you. You refer to rules that are in Part 3 of Chapter 18. They do not apply to this appeal. I'm very pleased to see that you're looking at the Uniform Civil Procedure rules, but you must look at Part 1, Rules 744 to 777.
Objection, ma'am.
To facilitate the hearing of your appeal, I have asked you whether you want the registry to prepare the appeal book at no cost to you. There is a power under Rule 759 for that to be done, and I'm proposing to help you by directing the registrar to prepare the appeal record book at no cost to you.
Thank you.
Do you wish for that to be done?
Since you're here to help me with your fiduciary duty as trustee and administrator today, I've instructed you to follow through with my emails to Gaydon's lawyers and Mr. Cooper with the cease and desist order, as they have only alleged facts and no actual proof at all of me owing any money. In fact, it's not only am I not the lender, not only am I not the borrower, I am in fact the lender of this.
25 October 2024.
I'm sorry, what was that? I can't hear you.
Do you wish to appeal against the order made by Judge Barlow on 25 October 2024?
Are you referring to the one that was done in ex parte, behind my back, without my consent? Is that the one you're referring to?
Well,
I wasn't informed of that, so that's null and void anyway, ab initio. It's void from the beginning because it was done with criminal activity by Gaydon's, Barbara, Mr. Cooper. I don't know Mr. Cooper, but him, and I'll find out who DJ Cooper is, and then we'll go after him as well for criminal activity. But Barbara, Susan, Mark Peacock, yourself, and anybody in that room that's committing a criminal offence without my consent. You're the administrator, you have a fiduciary duty of care. You will tell Gaydon's to either answer the questions that I've provided more than 30 times in my notice to admit facts and documents.
I've answered your question.
No. I'm not asking you. No, sorry. Please let me repeat myself. I wasn't asking you to answer. I was not asking, ma'am, you need to calm down.
Continue with your appeal, or would you like me to strike it out?
You need to calm down. You need to relax. You seem like you're about to blow a blood vessel. Are you okay? Do you need some water?
Do you want me to strike out your appeal for want of prosecution?
You are directed to follow through with my cease and desist order with Gaydens. That's what I'm directing you to do. Your trustee and your fiduciary duty of care at statutory court is to follow through with your directions. You've been given directions. You have been given directions, man. You have been given your directions. You either ask them, ask Gaydens, ma'am. I was not invited to that courtroom. That was done behind my back. I don't know what that is.
That appeal being heard.
I'm not in your sandpit. You need to answer my questions in writing. I want to confirm with your autograph that you're in accordance with Chapter 3 of the 1901 Constitution. When that is in writing and you've signed it, then we'll go forward. I will then give you authority to move ahead. I have given to Gaydens lawyers, and all of them, more than 30 times, a notice to admit facts and documents. I've asked the Court of Appeal to follow through with that. You will have them answer the questions, or you will follow through with the cease and desist order. The matter is discharged. You will follow through. Man, why do you keep interrupting people? Why do you keep interrupting people?
Facilitate the hearing of your appeal, but you are not responding to the questions that I have asked you.
Yes, but you're not responding to my questions.
Do you want to continue with your appeal? If you do not answer my questions, I can strike out your appeal for want of prosecution.
I'm sorry, are you threatening me, are you, ma'am? Is this a threat?
With your appeal against Judge Barlow's order made on 25 October 2024. Do you wish to do it? But you have filed a notice of appeal. You have engaged the jurisdiction of this court.
Oh, no, I haven't. Oh, no, objection. I have not given jurisdiction to the court. The court is a statutory jurisdiction. It's a subsection of the Supreme Court. And I've already looked up the date. You were appointed there on the 21st of May, 2022. You are administrator only, and you have absolutely no jurisdiction without my consent, and you damn well know it. So you can say whatever the fuck you want, and you can talk over me as much as you want. But whatever you do, it will be used in a court of law, whether it's the High Court, the Federal Court, or the IC. Overseas, I don't care. You want to take my house, you do it, but you're breaking the law if you proceed. I am the equitable holder of this property. I am flesh and blood. My name is Scott, and I stand in equitable title holder. You are an administrator. You are trustee, and you will do a cease and desist. You will follow through with the cease and desist on Gaydens lawyers. The matter is discharged. Nothing more will happen. They will pay their penalties towards me for the loss, harm and injury they've caused me already. And you will be a part of that if you don't fulfil your fiduciary duties. Up to you. It's up to you. What you do is totally up to you. I'm not going to change your mind in any way, shape or form. I'm just letting you know that you will be held accountable. I want you to answer my questions. Can you please, let me say it as politely as I can. Can you please, is it Miss Mullins or Mrs. Mullins? Can you please have Gaydens provide the answers to the questions in the document I've sent them? I sat with Barbara Ansim, a colleague of mine, in her office. We recorded that conversation too, just like I'm recording this one. And we confirmed on and for the record that she would have any questions that we put to her. She told us to do this. She would have them answered. And since the date of that time, she has gone radio silence and not answered any of our questions. So we know there's fraud taking place. And I do know she committed perjury and told Miss Clare, the judge Miss Clare, that I was personally served and I was rude and abrupt. I get all of the lies and the propaganda. I've recorded all the information too. And I will use that as evidence against all of yous. And you'll all go to jail and lose everything you've worked for under Magna Carta 1215. I'm happy to follow the law. And I'm the only one here following the law. So you will all be breaking the law. We are breaking the law under statute law. Now, I do not mind if you want to be a criminal. That's up to you. But legislation is not law. Legislation is not law. So you need to ask.
His email address?
Are you talking to me or somebody else? I'm sorry. I can't see you.
I'm instructed that an email was sent to the appellant providing a link to a location where all the documents were saved and accessible.
Objection.
So, I just asked Mr. Ananian Cooper, so I picked up in the email correspondence that you were wanting copies of documents.
No. Objection. I want the questions answered to my notice to admit facts and documents. Barbara Ann sat with me and told me she'd answer the questions. Susan Forrest from Gaydon's lawyer also did the same thing. Mark Peacock has copies of it. Everybody, including the Court of Appeal, I've come to you for your assistance because I've got Gaydon's, which has a class action against them, stealing people's properties. So I'm asking you to do your job, your fiduciary duty of care for me, and either ask them to answer the question. Ma'am, all I want is the questions answered. I only want the one document answered. Please instruct them to answer the question or discharge the matter. This is it. That's your choices. You don't get another choice. Any other choices you do...
The attends at the address to pick up mail. That's what I've gleaned.
Yeah, I was going to say it's not clear to us that he resides there.
No, I don't think he resides there. But I picked up that the appellant doesn't have access to a computer, or he has an old phone. So sending him a link would not have given him access to the documents. So what I'm going to do is I will direct the solicitors for the respondent.
Sorry, Your Honour, sorry to interrupt. I am instructed that on the 4th of October 2024, Judge Claire SC ordered my client to produce certain documents by posting a copy to his address of service in Currumbin Waters.
Oh, so they were posted there.
That's what order was complied with.
Yes, objection. I was not living at that address, although that is my equitable home and my flesh and blood paid for it, and I will continue to keep my property. My private property will stay in my hands. And the... Well then, please, okay, thank you. Thank you for helping me. Can you... Thank you for helping me. Thank you for confirming that you're helping me. I appreciate that. I do appreciate that your help, because I truly don't know what I'm doing. So if you really truly want to help me, ma'am, if you truly want to help me, as the president of the Supreme Court Subdivision Appeals Court, if you truly want to help me, you will direct Cooper to have Gaydon's lawyers answer the questions in the document. Mark Peacock has many copies. Susan has plenty of copies. Jackson has plenty of copies. Barbara Ann Sim has plenty of copies. The Court of Appeal has plenty of copies. They're actually sitting in front of me on my desk right now. I need the questions answered. I need to verify, because in their own statement on the original document that they gave me a copy of a long time ago, when I first started protecting myself from these criminals, is everything they're doing is based on alleged. They have absolutely no facts of evidence, just based on alleged. So if they could answer my questions, please, if you're here to help me, then have them, direct them to answer my questions. Once those questions are answered, you and I can have a discussion. If they can't answer those questions give them a week, give them a month, give them a year. I don't care. Give them some time, whatever they require. Answer the questions with material evidence. And once that's done, you and I can discuss this matter again. Now, if they can't provide the answers, which they've gone radio silence and won't provide the answer, because they know they can't, because they know they're breaking the law, right, what will happen then is you will instruct them to cease and desist the matter. And that is you helping me as you claim. And I appreciate you helping me as you claim. And I will thank you, absolutely be in your debt for that.
Can I just ask you, I'm going to direct the solicitors for the respondent to provide hard copies of all documents relied on by the respondent before Judge Barlow.
Judge Barlow will be going to jail because he practiced law from the bench as an administrator.
25 October 2024 by leaving them for the appellant to collect.
Miss Mullins, is it Miss or Mrs.?
I have got to make my directions.
You've been given your directions by Scott, the grantor. In this matter, I am the grantor. You are acting as trustee and administrator today. That is your role. That can't be changed unless I give permission. Implied.
Where would you like to collect the documents from? Can you just nominate
I'm going to acknowledge this. Your directions from me is follows. You have them answer the questions, admit the document entitled Admit facts and documents. Once they've answered the questions, then you and I will talk. Once they answer the questions, you and I will. Once they answer the questions, you and I can talk about the matter. Until then, as trustee, you will follow through with your fiduciary duties, and you will force their hand to answer the questions, or you will follow through with my choice to make a cease and desist order against Gatens.
So is there a post office at Currumbin? Would that be the appropriate post office?
So the notice to admit facts and documents is what you'll have direct them to answer. Thank you for that, for helping me as you claim, and I do appreciate you being here today. I did ask for you personally in an email. I'm glad you're here. I'm not sure if you're aware, but in 2008, all courts in Australia adopted the 1942 Clearfield Doctrine and became yes. I'm aware of the document. It's freedom of information. It's a government document. It's a government document. And being a government document, you have a fiduciary duty of care towards me, ma'am, and you will follow through it. You've been directed to ask Gatens. You haven't asked him yet. I haven't heard it anyway. You will direct them to answer the questions on the document entitled Facts and...
Can you check where there's a post office, whether it's at Currumbin Waters or Currumbin?
I do apologise. It appears that you can't hear me. Is my phone on? Am I muted? You're ignoring me. Is that what you're doing? No. See, I am. You've got to respond to mine first, though. You're the trustee in this matter, not me. So, as trustee, you will respond to my questions. You will either put the cease and desist order and move Gatens along. And of course, there's going to be obviously a fee attached to Gatens with the harm, loss and injury towards myself, my flesh and blood, and the headache they've created. And you, or I should say, I apologise, or they can answer the questions. It's that simple. I've never said I won't pay. I've never said any of the above. I'm happy to. I just need proof of fact. And that's all I've been asking for. And I'm sure when we go to the High Court and I do the same thing again, and it is in the tort of common law...
You don't get a hearing in the High Court.
Oh, mate, I will do whatever the hell I want. I'm entitled to a free court. Under the Courts Act of 1400, everybody's entitled to court. Everybody's entitled to their day in court. And this, like, for example, today, for my time that I'm being wasted, it's a $50,000 for my performance fee. Now, who's paying that? You or the clerk? Who's writing the cheque? You or the clerk? Because one of you need to write a cheque for today's effort. As trustee, I'm assuming it's you. But if you want the clerk to do it, I know that they've brought the matter in anyway. And I'm aware of barratry, and I'm aware of false claims, and I'm aware everything they've based it on is an alleged fact and nothing more. I'm also aware of the perjury that Judge Clare admitted, and I'm aware that you're an administrative court, and I'm aware that no courts in Australia have authority.
A draft index of the appeal record book. So what day next week can you post all of the hard copies of the documents relied on before Judge Barlow KC on 25 October 2024?
Judge Barlow was stood down and placed under common law arrest. So you should be aware, Ms Mullins, that Judge Barlow is placed under common law arrest for practising law from the bench and perverting the course of justice, acting outside jurisdiction. So I'd hate to have to put you under arrest too for those same crimes. It is under the Crimes Act, and I'd like to remind you that you do not have immunity. All presumptions of law, all 12 presumptions of law, but not limited to.
The directions to you so that you've got them and you can look at them.
So you're happy to commit perjury in this recording, are you? Awesome. So you are breaking the law and practising law from the bench.
This is the first direction.
No. Oh, sorry, ma'am. Are you talking to me or somebody else?
Direct that on or before 4 p.m. on 7 November 2025, the solicitors for the respondent send.
Are you talking to me? I can't hear you.
I'll say it again. All right. Direct that on or before 4 p.m. on 7 November 2025, the solicitors for the respondent send by prepaid post hard copies of the documents relied on by the respondent before Judge Barlow KC on 25 October 2024.
Objection.
To tell us for collection at the post office at Currumbin Warden's...
Objection, Ms Mullins. That won't be happening. You will have them answer the questions on the document that I've mentioned 10 times. You will direct Gaydens to answer those questions and I'll pick that up. That's what I'm assuming I'll be picking up. Answers to the questions. Answers to the questions on the document titled Knows to Admit Facts and Documents. You will direct them to answer the question or you will have a cease and desist order put against them. You've heard me. Your fiduciary duty of care is what it is. You've been instructed by me, the grantor.
Actually, direct that the appellant respond to the draft index.
You're not very good at this, are you?
Of the appeal record book
With... You okay? Do you want some time?
Direct that the appellant respond to the draft index of the appeal record book with any suggested additions or deletions on or before 28th November 2025. Now, I'm going to set down your appeal. I'll give you a date.
You give me a date?
Give you a date so that you can come to court.
Oh, no, that won't be happening until you answer the question I've instructed you to do. Ms Mullins, you have been directed to answer the questions. Direct the Gaydens lawyers to answer the question. Why do you claim you're helping me if you're not going to ask them to answer the questions?
On a timetable.
Ms Mullins, why are you not directing them to answer the basic questions? Why are you not doing that? Why is it you're not doing that? If you're here to help me, as you've said, now I've mentioned before you are being recorded, and I have sheriffs here. I have sheriffs here in a JP, and we are recording this and we'll be doing affidavits in regards to yours. You are not fulfilling your fiduciary duty. You've been instructed to do a cease and desist or have them answer the questions. Why will you not just ask Gaydens to answer the questions so we can resolve this issue? I'm looking for remedy, and how I get my remedy is proof of facts. They need to prove to me. If they want to make me an offer and buy my properties out, I'm happy to do that as well. I want a written offer and they can purchase the land off me, the house, my private property. If they wish to have it this badly, I will give them the opportunity. Okay, so I'm giving you remedy here. I'm giving you choices here. I've given you 3 choices. I've given you... No. So, Ms Mullins, you don't understand that I'm in charge here, not you. You've been instructed. You've been instructed to follow through.
The draft index of the appeal record book with any suggested additions or deletions on or before 28 November 2025. 3. Direct the parties liaise with the registrar on a timetable for the filing of submissions after the appeal record book index has been finalised. 4. Direct the registrar to prepare the appeal record book at no cost to the appellant.
I'm not the appellant. Objection, Deborah. You will not refer to me as the appellant. You will not do that. My name is Scott. I am flesh and blood. I am the equitable law here, not you. You will, as trustee, fulfil your fiduciary duty and make a choice, cease and desist, or have them answer the questions, or have them make an offer. That's your choice. That's your only choice. All that other nonsense and gobbledygoosh that you went through then is irrelevant. You are not in charge here. Make no mistake. I know who you are. I know what you are. I'm aware of what your position, and you will be held accountable, including that DJ, was it? Sorry, Cooper? I can't remember. I wrote it down, but I can't remember. But make no mistake, the gig's up. Most people know of the corruption and the Ponzi scheme through the courts. We are fully aware of it, and it's not going to be pretty. You will fulfill your fiduciary duty, or this live recording, this will go live. Make no mistake, this is for public use. You will fulfill your duty. I don't care how you do it to your satisfaction, but as long as I'm satisfied at the end. Fulfill your fiduciary duty to me as trustee. That's the only thing. You've got 3 choices. Follow through with one of those choices. They make an offer that we agree upon. They answer the question, or they answer the questions on the facts or the notice of facts and documents, or it's cease and desist. That's your only choices. That's your only choices. You gave me your word and you mentioned it several times. Bitch hung up on me.